Hello and welcome to my video. This video will be covering the facts and findings in the case of the Australian Video Retailers Association and Warner Home Video Proprietary Limited, which was heard before the Federal Court of Australia in 2001. The applicants, the Australian Video Retailers Association, commenced proceedings that the respondents, Warner Home Video, had made unjustified claims of civil and criminal proceedings for infringement of copyright, and that such infringements contravened Section 52 of the Trade Practices Act by engaging in conduct in trade or commerce that is misleading or deceptive. The respondents, in turn, by cross-claim, sought declarations that copyright in the motion pictures embodied in certain DVD discs would be infringed by a person whom, without the explicit consent of the respondents, rents and plays a DVD disc that embodies those motion pictures. They also sought declarations that copyright in certain computer programs will be infringed by entering into commercial rental arrangements in respect of those DVD discs that embodied those computer programs. Pursuant to O29 of the Federal Court rules, both parties formulated preliminary questions that were paramount to the case, which, once answered, were purported to solve the dispute in its entirety. These questions related to two discs, the Bait DVD disc and the Romeo Must Die DVD disc, two DVDs that were rented out by commercial arrangements. The first question was, does a person who plays the DVD discs make a copy of the whole or a substantial part of the embodied film in the course of playing the disc on either a DVD player or a personal computer? In relation to this question, the court assessed whether the playing of a DVD disc constituted the doing of the act referred to in Section 86A of the Copyright Act, namely, making a copy of the film embedded in the DVD disc. The essential test employed by the court regarded a question of substantiality as well as an inquiry into the purpose of the copying. It was determined that the embodiment of volatile, tiny fractions of visual images and sounds that comprise a film or motion picture did not constitute the act of making a copy of the motion picture or film. The second question was, what computer programs in which copyright subsists are embodied in the DVD discs? The court had regard to the definition of computer program, which is defined in the Act as a set of statements or instructions to be used directly or indirectly in a computer in order to bring about a certain result. The court then attempted to identify any types of statements or set of instructions in the DVDs. In this case, the computer programs were intended to cause the DVD player to play and navigate through the audio, visual, and caption content. By reference to professional evidence, it was determined that the material on the DVD discs in question that constituted computer programs were limited to program instructions and did not extend to the audio, visual, and caption content of the DVD discs, which rejected the claims purported by Warner. The third question that the court had to answer was, when a video store proprietor enters into a commercial arrangement involving the hire of the DVD discs, does any of the computer programs referred to in the answer to question 2 constitute the essential object of the rental within the meaning of Section 31, paragraph 5 of the Act? The question therefore before the court was whether the computer programs constituted the essential object of the rental that would arise under such commercial rental arrangements. After discussing the possible enhanced features of a DVD player and any relevance of this, the court rejected any relevance of the enhanced features of a DVD player, having determined that the essential object is to obtain the capacity and right to experience the motion picture in both its video and audio aspects. The final question before the court was, does a person who plays the DVD discs on either a DVD player or a personal computer reproduce in a material form the whole or substantial part of the computer programs referred to in question 2? The question before the court was whether the copying of a substantial part of such computer programs involved the reproduction of the computer programs being a literary work in a material form within the meaning of Section 31 of the Copyright Act. After considering the particular ways in which ROM and RAM, which are forms of digital memory, are stored, it was determined that in the ordinary course, temporary storage of a substantial part of the computer program in either ROM or RAM in a DVD player will not involve a reproduction of the computer program in a material form. By answering the preliminary questions put forward to the court pursuant to 029 of the Federal Court Rules, the court then ordered for proposed orders by either parties to give further consideration to the conduct of the proceeding.